A boarded an airplane at the Manila Domestic Airport bound for Davao City. While the airplane was still on the tarmac, its door is still open and waiting for the last passenger to board. A ordered the pilot at gunpoint to take the airplane to Singapore. When the pilot refused, A shot him to death. Hijacking is not committed since the aircraft is not yet in flight. Neither is attempted hijacking committed. Article 6 of the Revised Penal Code on Attempted Crime will not apply since RA number 6235 did not adopt the technical nomenclature of the penalty of the code. The intention of the law is not to adopt the penal provision under the code, including Article 6 on attempted crime in relation to Article 51 on graduation of penalty. Hence, the crime committed is murder. Offender committed hijacking of PAL airplane within the territory of San Francisco. The Philippines, for being a flag state, has territorial jurisdiction over the crime of hijacking because of the flag state rule under Article 2 of the Revised Penal Code. Moreover, hijacking is a universal crime. Hence, all courts, including that of the Philippines, have jurisdiction applying the universality principle under international law. A. Ordered the pilot to take the PAL airplane to Sabah instead of Cebu. The pilot obeyed for a while and then wrestled with A for the possession of the gun. In the struggle, A shot and killed the pilot. The crime committed is qualified hijacking. This is not a complex crime under Article 48 of the Revised Penal Code, but a special complex crime of hijacking with homicide, since the law RA 6235 prescribes a single penalty for committing two crimes. Moreover, an offense punishable under special law, such as hijacking, cannot be made a component of a complex crime under Article 48 of the Code. A police officer implemented a warrant of arrest for robbery against B. B posted bail. 3 days later, A sees B at the cockpit and immediately arrests him. B was telling A that he was out on bail, but A would not believe him. A did not make effort to verify if B had really been released on bail. A is not liable for arbitrary detention since he acted without malice, but for failure to verify the order of release before proceeding to make the rearrest, he is liable for simple imprudence resulting in arbitrary detention. Gina was apprehended and arrested by patrolman Bartolo for illegal parking. She was detained at the police precinct, underwent investigation, and released only after 48 hours. Under RA number 4136, or the Land Transportation and Traffic Code, the general procedure for dealing with a traffic violation is not the arrest of the offender, but the confiscation of the driver's license of the latter. Moreover, under the rules of court, a warrant of arrest need not be issued if the information or charge was filed for an offense penalized by a fine only. It may be stated as a corollary that neither can a warrantless arrest be made for traffic violation involving illegal parking, since the penalty for this crime is fine only. What is the crime committed? Since the arrest is illegal, the crime committed is not delay in the delivery of detained persons to the proper judicial authorities under Article 125, but arbitrary detention under Article 124. Jose and Pedro proposed to the former soldiers that they recruit their comrades and organize a group of 100 for the purpose of challenging the government by force of arms in order to prevent the implementation of the land reform law in Cotabato province. Jose and Pedro promised to finance the group and to buy firearms for that purpose. The former soldiers agreed. They are liable for conspiracy to commit sedition. Jose, Pedro, and the former soldiers agreed and decided to rise publicly and tumultuously and by means of force or intimidation to prevent the promulgation or execution of any law. What is the proper charge against a person who, without taking arms or being in open hostility against the government, shall incite others to deprive Congress of its legislative powers by means of speeches or writings? Inciting to sedition of the second form, since the offender uttered seditious speeches or writing which tend to disturb or obstruct any lawful officer in executing the functions of his office, tend to instigate others to cabal or meet together for unlawful purposes, or lead or tend to stir up the people against the lawful authorities, or lead or tend to disturb the safety and order of the government. Q. What kind of crime is committed with the following? They committed a real abuse in seizing the flag. The members of the constabulary are bad because they shoot even innocent women, as it happened in Tayug. In view of this, we ought to be united to suppress that abuse, overthrow the present government, and establish our own government, the government of the poor. Use your whip so that there may be marks on their sides. The person who delivered the speech is liable for inciting to sedition of the second form, since his speech instigated the poor to cabal and meet together for unlawful purpose. Number 2, suggested and incited rebellious conspiracies. And number 3, tended to stir up the people against the lawful authorities. And 4, tended to disturb the peace of community and the order of the government. Q. The Filipinos, like myself, must use bolas for cutting off Wood's head for having recommended a bad thing for the Filipinos, for he has killed our independence. People versus Perez. This is inciting to sedition of the second form, because the words uttered instigated the poor to cabal and meet together for unlawful purpose. Number 2, suggested and incited rebellious conspiracies. Number 3, tended to stir up the people against the lawful authorities. And 4, tended to disturb the peace of the community and the order of the government. Q. A was sleeping on the floor. Immediately beside him was a clutch bag containing a loose firearm. He was arrested. A maintained that the bag containing the unlicensed firearm belonged to his friend, and that he was not in actual possession thereof at the time he was arrested. Answer. His argument is untenable. The rule is that ownership is not an essential element of illegal possession of firearms and ammunition. What the law requires is merely possession, physical or constructive. Moreover, A has constructive possession over the loose firearm, since the same is under his control. Possession within the meaning of RA number 10591 includes not only actual physical possession, but also constructive possession, or the subjection of the thing to one's control and management. Q. A security agency delivered to X, its security guard, a firearm. X was arrested for possession of loose firearm. It turned out that the agency has no license for said firearm. Is X liable for the possession of loose firearm, which is an offense punishable under a special law? Yes. X is liable for possession of loose firearm, which is an offense punishable under the special law. It is a malum prohibitum, lack of knowledge that the firearm delivered to X by the security agency has no license is not a defense. Although there was no criminal or evil intent on the part of X, what is important is he intended to perpetrate the act prohibited by law. The possession of X in this case is coupled with animus possidendi. A, B, and C organized a meeting in which the audience was incited to the commission of the crime of sedition. Some of the persons present at the meeting were carrying unlicensed firearms. What crime or crimes can be filed against A, B, and C? A, B, and C are liable for illegal assembly as organizers thereof. Armed and unarmed persons who are merely present at the meeting are also criminally liable for illegal assembly. A person armed with an unlicensed firearm is considered a leader or organizer of the meeting, even though he was merely present thereat. However, since illegal assembly is a felony, one cannot be held liable for this crime on the basis of being present at the meeting without criminal intent or dolo. Thus, If a person happens to be present at an illegal assembly out of curiosity, he is not liable for illegal assembly. It is submitted that to make persons who attended the illegal assembly criminally liable, they must be incited to commit treason, rebellion, sedition, or direct assault. Passive presence in the meeting will not make them liable for illegal assembly. Reyes. 6 armed men in a house conspired to kill Pedro. Are they liable for the crime of conspiracy to commit murder? No. They are not liable for the crime of conspiracy to commit murder, since there is no law prescribing a penalty for it. However, they are liable for illegal assembly. Q. Peeved by the denunciations of extrajudicial killing by Father Chris in his homily, Policeman Stone, a parishioner, approached the priest during the homily, openly displayed his firearm tucked in his waist, and menacingly uttered at the priest, "Father, may kalalagyan kayo kung hindi kayo tumigil." The celebration of the Mass was disrupted, and the congregation left the church in disgust over the actuations of a co-parishioner. 2017 bar. Is Police Officer Stone liable for interruption of religious worship? No. The police officer is not liable for interruption of religious worship. In People v. Calera and Cantella, interruption of peaceful meeting is not committed where the accused is a participant of the peaceful meeting. Applying the case of Calera and Cantella case by analogy, interruption of religious worship is not committed since Policeman Stone is a participant to the religious worship. Moreover, one of the elements of interruption of religious worship is that the offender must be a public officer. However, in this case, Policeman Stone did not make the threatening statement, which disrupted the Mass celebration in his capacity as a public officer. However, Policeman Stone is liable for offending religious feeling. To be held liable for offending religious feeling, the notoriously offensive act must be directed against religious practice, dogma, or ritual. U.S. versus Bias. In People versus Migalos, August 15, 1955, the accused who threw a piece of coconut trunk at the minister who was spreading the tenets of his sect and challenged him to a fist fight was convicted of offending religious worship. In this case, the act of Policeman Stone is directed against the practice of the Christian Church of expressing their opposition to the extrajudicial killings. Moreover, settled in the rule that whether or not an act offends the feelings of the Catholics should be viewed or judged from the latter's point of view and not from that of the offender. People versus Bias. In this case, congregation left the church in disgust over the actuations of Policeman Stone. Hence, his acts notoriously offended the religious feelings of the parishioners. According to Mariano Albert, an act is said to be notoriously offensive to the religious feelings of the faithful when a person plays with or damages or destroys any object or veneration by the faithful. Remarks that those who believe that Christ is God are Antichrist, that all members of the Roman Catholic Church are marked by the demon, and that Pope is the commander-in-chief of Satan, are notoriously offensive to the feelings of the Catholics. Mandoriao versus CA. The statement, "Come on now, they are already starting, let us have a jam session," is not notoriously offensive. Hence, the crime committed is unjust vexation. People versus Tamara. A tour guide, Carlos Celdran, in protesting against the church opposition to the reproductive health bill dressed like Jose Rizal, stood in front of the main altar of Manila Cathedral during an ecumenical service, shouted and raised a placard with the word Damaso on it. He was convicted by the trial court of offending religious feelings. From the book authored by Judge Campanilla. A attacked B, a policeman who was on his way to buy a lotto ticket. Is A liable for direct assault? No. A is not liable for direct assault since B was not engaged in the performance of his official duties or on occasion of such performance at the time of the assault. The crime committed is physical injuries. 1995 bar. Q. A. Attacked B. A mayor who was delivering a campaign speech for his re-election bid. Is a crime of direct assault committed? No. Direct assault is not committed since the victim was not engaged in the performance of his official duties or on occasion of such performance at the time of the assault. 1971 bar exam. The crime committed is slight physical injuries, serious physical injuries, or attempted or frustrated homicide with the aggravating circumstance of disregard of rank. People versus Ablau. Q. A. A barangay chairman was presiding over a meeting regarding cleanliness of the community when he was immediately assaulted by B, his creditor, whom he has not paid for a long time despite his repeated promises to pay. What is the crime committed? The crime committed is direct assault, although the motive behind the assault is personal, since he was engaged in the performance of his duty at the time of the assault. 1977 bar exam. Q. Pañuelito struck Judge Manolo, who previously cited him in contempt on the street. What is the crime committed? The crime is direct assault, since he was assaulted by reason of past performance of his duty. 1993 bar. But attacking a retired judge on his 71st birthday by reason of past performance of his judicial duty is not direct assault, since at the time of the assault, he is not a person in authority anymore. Note: the mandatory retirement age of a judge under the Constitution is 70 years. 2009 bar exam. If the person in authority or his agent is engaged in the actual performance of duties at the time of the assault, the motive for the assault is immaterial. Direct assault is committed even if the motive was totally foreign to victim's official function. If the person in authority or his agent is not engaged in the actual performance of duties at the time of the assault, the motive for the assault is material. If the assault is by reason of the past performance of official duties, the crime would be direct assault. Otherwise, it would only be physical injuries or threat, depending upon the circumstances of the case. While on patrol duty, a policeman encountered the accused and asked the officer if he wanted to fight, to which the policeman replied in the negative. The accused suddenly punched the police officer. Is there a direct assault? Answer: direct assault is not committed because of lack of intent to defy the law and its representative. Simple resistance is not committed since the accused is not resisting the performance of function of the police officer. Hence, the crime committed is slight physical injuries. On a different occasion, the same policeman who was on patrol duty encountered the same accused, and the accused stated to the policeman, "Putang ina mo, patayin kita." What is the crime committed? The crime committed is threat. Yet, on another occasion, the same policeman who was on patrol duty encountered the same accused. The accused asked the officer if he wanted to fight, to which the latter replied in the negative. The accused seized the policeman by the throat, threw him to the ground, and struck him several blows with a club, which he succeeded in wresting from the policeman. What is the crime committed? The crime committed is direct assault because the attack upon him while he was engaged in the performance of his duty is serious, which shows intention to defy the law and its representative at all hazard. U.S. v. Cox, January 6, 1904. Q. X. A detention prisoner escaped from prison by disarming the guards with the use of pistol. What crime or crimes is he liable for? X is liable for direct assault, serious intimidation with intention to defy the law and its representative at all hazard constitutes this crime. 2016 bar exam. However, a convicted prisoner who escaped from prison by disarming the guard is liable for evasion of service of sentence with the qualifying circumstance of use of intimidation. Direct assault is absorbed in qualified evasion of service of sentence. A police officer implemented a warrant of arrest against a senator for frustrated homicide, punished by prison mayor 6 years and 1 day to 12 years, while the Congress is in session. Is the police officer liable for a violation of parliamentary immunity? Under Article 145 of the Code, a legislator is immune from arrest for offense punishable by not more than 12 years of imprisonment. 2012 bar exam. However, under Section 11, Article 6 of the 1987 Constitution, the immunity from arrest is limited to offense punishable by not more than 6 years of imprisonment. It is a settled rule that the revised penal code cannot enlarge the parliamentary immunity under the Constitution, Martinez v. Morphe. Hence, portion of Article 145 of the Code on immunity on arrest for offense punishable by a penalty of more than 6 years of imprisonment is inoperative or unconstitutional. Therefore, the police officer is not liable for a violation of parliamentary immunity under Article 145, since the penalty for frustrated homicide, for which the warrant is issued, is more than 6 years of imprisonment. Q. When is evasion a continuing crime? Evasion of service of sentence involving the penalty of imprisonment is a continuing crime. Thus, if the convict escaped from National Bilibid Prison in Muntinlupa and was arrested in Manila, he can be prosecuted for evasion of service of sentence either in Muntinlupa or Manila. However, in evasion of service of sentence involving the penalty of destierro, the violation of sentence by the accused ceased once he gets out of the prohibited area. Thus, if the convict who entered Dagupan City, which is a prohibited place by reason of the penalty of destierro, and thereafter he went to Manila and was arrested in that place, he can only be prosecuted in Dagupan City. When he was arrested in Manila, he is not anymore violating the penalty of destierro, since that is not a prohibited area. In sum, evasion of service of sentence involving destierro is not a continuing crime. 1998 bar. Q. A. Took the place of B, who had been convicted by final judgment, not using his own name. What charge or charges can he be liable for? A is guilty of the crime of using a fictitious name under Article 178, since he used a fictitious name to conceal the crime of delivering prisoners from jail. This is not a complex crime proper. Delivery of prisoner from jail is already consummated when the accused uses fictitious name to conceal his crime. Hence, using fictitious name is not a necessary means to commit delivery of prisoner from jail. 2012 bar. A. Furnishes B, a detention prisoner, with a pistol which he used to facilitate his escape. What crime is committed? One who furnished a detention prisoner with the material means or tools which greatly facilitate his escape is liable for delivery of prisoner from jail. Hence, providing pistol which helped the prisoner to escape is delivery of prisoner from jail. 2015 bar. A. A detention prisoner was taken to a hospital for emergency medical treatment. His followers, all of whom were armed, went to the hospital to take him away or help him escape. What is the crime committed? The detention prisoner is not liable for evasion of service of sentence, since this crime can only be committed by a convicted prisoner. However, his followers are liable for delivery of prisoner from jail. The crime can take place outside of the penal establishments by taking the guards by surprise. 2002 bar exam. A detainee worked at a guest house pursuant to a note of the governor to the assistant provincial warden asking for 5 men to work in the guest house. The notice did not mention the name of the prisoner. The warden merely picked the men to compose the work party. While working, the detention prisoner for homicide escaped. Who are liable, and what are they liable for? The governor and the assistant provincial warden are not liable for delivery of prisoner from jail, since they are jailers of the detention prisoner. This crime is committed by an outsider who removes from jail any person therein confined or helps him escape. They are not liable for connivance in the evasion of the prisoner. For sure, no connivance in the escape of the detention prisoner can be deduced from the note of the governor, which does not mention the names of the prisoners to be brought to his guest house. They are not liable for evasion through negligence, since this crime can only be committed by the officer who is charged with the custody and guarding of the prisoner. 1981 bar exam. But a guard is liable for infidelity in the custody of prisoner or evasion through negligence, for relaxing the inspection of belongings of a detention prisoner during jail visit, allowing him to smuggle a pistol, which he subsequently used to escape. 2015 bar exam. Q. X is serving a 6-year prison term. In his 4th year in prison, he discovered that the judge committed a mistake in giving him a 6-year sentence when the law he violated called for 3 years of imprisonment only. Y, the jail guard, and a law student checked X's contention and found it correct. X did not want to go to court anymore, as he did not have any money to hire a lawyer to file habeas corpus, and he had lost faith in the competence of judges. X then informed Y that he would just escape, and the latter did not object. As soon as Y turned his back, X sprinted out of his cell. What are the crimes committed? X is liable for evasion of service of sentence, while Y is liable for consenting to evasion. The fact that the judge committed a mistake in imposing the penalty is not an excuse for escaping. X should have availed of procedural remedies under the law by assessing on his own the proper penalty and escaping on the assumption that he already served the correct penalty. He placed the law into his own hands, which is not allowed, since it will destroy the foundation of the judicial system. 1979 bar. Q. The brother of a detention prisoner and convicted prisoner bribed the clerk of court to falsify release order and their custodians to release his brothers. What are the crimes committed? The convicted prisoner, but not the detention prisoner, is liable for evasion of service of sentence. The brother and the clerk of court are liable for delivery of prisoner from jail with respect to the escape of the detention prisoner and convicted prisoner. Custodians are liable for infidelity in the custody of prisoners with respect to the escape of the detention prisoner and convicted prisoner. The brother is liable for 2 counts of corruption of public officer. The clerk of court and the custodians are liable for direct bribery. The clerk of court and brother are liable for falsification of document as principal by direct participation and as principal by inducement, respectively. 2009 and 2014 bar exam. Q. On the date of hearing, a custodian removed the handcuff of a detention prisoner and allowed him to sit on one of the chairs inside the courtroom. As the custodian was talking to the lawyer inside the courtroom, the detention prisoner, with the help of a cigarette vendor, escaped. Who are liable for his escape? The detention prisoner is not liable for evasion of service of sentence, since this crime can only be committed by a convicted prisoner. The custodian is liable for infidelity in the custody of prisoner or evasion through negligence. The vendor is liable for delivery of prisoner from jail. 1989. Q. To pay the unpaid beer house bill in the amount of $2,000, A, B, C, and D agreed to commit robbery. Armed with weapons, they hailed the first taxicab and robbed the driver in the amount of $1,000. Since they need $1,000 more to pay the bill, they hailed another taxicab and robbed the driver again. What crimes did they commit? They are liable for 2 counts of robbery by band. Even if the victims are indiscriminate rather than predetermined, since there is no showing that the accused are previously committing robbery on the highway, and the robbery of which they are charged is an isolated incident to pay the unpaid bill, the crime is not highway robbery or brigandage. Highway robbers or brigands are those who are regularly and indiscriminately committing robberies on highways. The law on brigandage is designed to protect travelers against those who are making robbery on the highway as a profession. Even if A, B, C, and D, instead of robbing a taxi cab, robbed a jeepney in the highway in order to rob its passengers, and the 3 passengers put up resistance and were killed, after which they were divested of valuables, they are liable for robbery with homicide. They are still not liable for highway robbery or brigandage, since there is no showing that they are regularly committing robbery on the highway. 1971 and 2010 bar exam. Q. Without consent from the owner, A, B, C, D, and E, and F entered upon a part of tract of land, carrying with them iron bars, picks, and other tools and materials to build their respective houses, which they began to construct thereon. All this was done in the presence of X, the owner of the tract of land, who, afraid because of the attitude of the intruders, did not do anything to prevent them. What is the crime committed? Occupation of real property is not committed, since the intruders did not use violence or intimidation in occupying the property. The remedy of X is to file a judgment case against the squatters. On another occasion, A and B, both farmers, entered the land owned by X and planted palay thereon. When X came to know about it, he confronted A and B and inquired why the latter occupied his land and planted palay thereon. A, with a bolo in his hand, replied that the land belongs to the family of S and not to X, and at the same time said, "If you touch this land and my palay, blood will flow on this land." What crime is committed? The threat uttered by A to occupy the land of X constitutes the crime of occupation of real property. It did not give rise to the complex crime of usurpation of real property with grave threats under Article 48. The threat is the intimidation contemplated in the crime of usurpation of real property. Hence, the latter absorbs the former. Threat does not constitute a distinct crime. 1989 bar exam. 2. P occupied a parcel of land when the owner thereof went abroad. When the owner returned and tried to enter the land, P successively shot him for around 10 times to scare him from entering the land. The landowner was not hit. P was charged of usurpation of real property and attempted homicide for said acts. Is the charge correct? Usurpation of real property is not committed, since P did not shoot the owner for purposes of occupying the property. Because P already occupied the property, he merely committed the criminal act to prevent the owner from reoccupying the property. P did not commit attempted homicide, since he shot the owner not to kill, but merely to scare him. The crime committed is illegal discharge of firearm. 1977. Q. A group of homeless persons occupied the houses built by the National Housing Authority, NHA, for certain military personnel. To gain entry into the houses, the group intimidated the security guards with the firearms and destroyed the padlocks of the doors of the houses. They claimed that they were entitled to free housing from the government. What is the crime committed? They are liable for occupation of real property. The phrase acts of violence, which is the mode of committing occupation of real property, includes coercion. Hence, occupation of real property absorbs coercion. 2018 bar. However, if the group is composed of at least 4 armed men, the public uprising to prevent the NHA officers from freely performing their function of implementing the housing program of the government shall be deemed to be tumultuous. Hence, they are also liable for sedition. It is submitted that they can be prosecuted separately for sedition and occupation of real property. The phrase acts of violence, which is the mode of committing occupation of real property, does not include sedition. Jurisprudence treats sedition as a crime separate from those committed in the course thereof. People v. Umali. Q. What is the liability of the juror under BP 22? The liability of the juror under BP 22 is not merely civil in character, since the law imposes a penalty for issuance of a worthless check. 2014 bar. If the juror issued a bouncing check to defraud another person, he can be prosecuted for violation of BP 22 and estafa through issuance of bouncing without offending the rule on double jeopardy. The constitutional provision on double jeopardy shall not be offended by this dual prosecution, since these crimes are not the same in character. In sum, the charge of estafa does not include or is not necessarily included in the charge of violation of BP 22. Estafa is malum in se, while violation of BP 22 is malum prohibitum. Unlike in violation of BP 22, deceit employed by the offender and damage suffered by the offended party and their causal connection are elements of estafa. Moreover, Section 5 of BP 22 provides that prosecution under this law shall be without prejudice to any liability for violation of any provision of the revised penal code. 1983, 1987, and 2018 bar exam. Single act of issuing an unfunded check to defraud the payee is not a complex crime of estafa and violation of BP 22. Article 48 of the revised penal code speaks of grave or less grave felonies produced by a single act. Since violation of BP 22 is an offense punishable under special law, it cannot be made as component of a complex crime. 1987 bar. Q. On June 1, 2017, X bought a car from a company and paid it in cash and in check, dated July 31, 2017. He then brought the car to a friend's house and hid it in an underground garage. The check was dishonored for insufficiency of funds when presented for payment on the due date. X was asked to honor and pay the check or to return the car, but he refused. What is X liable for? X is not liable for carnapping or estafa through misappropriation, since he acquired ownership over the car by reason of contract of sale. X is not liable for estafa through issuance of bouncing check, since there is no showing that the check is already unfunded on the date of post-dating or on June 1, 2017, and he used his unfunded check to cause the company to part its car. However, X can be held liable for estafa through false pretense, since by hiding the car immediately upon buying it, it shows that his intention is to defraud the seller from the very start through deceit, similar to imaginary transaction. X is also liable for violation of BP 22, 2013 bar. Knowledge of the complainant of the unfunded condition of the check negates deceit on the part of the accused. Lack of deceit is a defense in estafa, but not in violation of BP 22, since the latter is malum prohibitum, 2002 and 2013 bar. To presume knowledge of insufficient funds as an element of violation of BP 22, the check must be presented for payment within 90 days from the date of issuance. If the check is presented beyond the period, such knowledge is not presumed. But the prosecutions can still present evidence, direct or circumstantial, that the accused at the time of issuance of check knew that it was unfunded. Hence, the action for violation of BP 22 can proceed despite the presentation of the check beyond 90 days period, 2018 bar. For example, knowledge of insufficiency of funds is established from the fact that the account of the accused was closed more than 4 years prior to the issuance of the subject checks, or where the accused requested the complainant not to encash the check with a promise that he would replace it with cash. What happens if the check is presented after 90 days? In the offense under the first paragraph, presentation of the check within 90 days from its maturity date is not an element thereof, but such presentation within the said period is required to apply the presumption of knowledge of insufficient funds, which is an element of the crime. Thus, there is no presumption of knowledge of insufficiency of funds if the check was presented beyond the period, but the prosecution may still prove such knowledge through other evidence. Bautista v. Court of Appeals. On the other hand, under the second paragraph, presentation of the check within 90 days from its maturity date is an element of the crime. The obligation of the drawer to maintain the sufficiency of the funds is confined to 90 days from the date of its issuance. Thus, presentation of the check beyond the period is a defense. Q. X. A police officer placed a hood on the head of W, a suspected drug pusher, and watched as Y and Z, police trainees, beat up and tortured W to get his confession. What is the liability of X? X is liable as principal for the crime of torture. Under Section 13 of RA 9745, immediate senior public official of the PNP shall be held liable as a principal to the crime of torture if he has knowledge that acts of torture are being committed by his subordinates and did not take preventive action during its commission. Section 13 of RA 9745 explicitly makes superiors criminally liable under the doctrine of command responsibility, 2011 bar. What is the effect of resignation from the public office in the case of malversation? Resignation from the public office is not a defense in malversations, since it is not listed in Article 89 of the Revised Penal Code as a mode of extinguishing criminal liability. This crime is committed if, at the time of misappropriation, the accused is an accountable officer, 2006 bar. Under Section 12 of RA 3019, no public officer shall be allowed to resign or retire pending investigation, criminal or administrative, or pending a prosecution against him, or for any offense under RA 3019 or under the provisions of the Revised Penal Code on bribery. However, a public officer facing criminal investigation or prosecution has the right to resign. Section 12 of RA 3019 merely prevents the act of resignation or retirement from being used by a public official as a protective shield to stop or prevent the investigation or prosecution of violation of RA 3019 or bribery. To be sure, no person can be compelled to render service, for that would be a violation of his constitutional right. A public official has the right not to serve if he really wants to retire or resign. Nevertheless, if at the time he resigns or retires, a public official is facing administrative or criminal investigation or prosecution, such resignation or retirement will not cause the dismissal of the criminal or administrative proceedings against him. He cannot use his resignation as an avoidance of prosecution. Estrada versus Desierto. Q. A. A city engineer misused government funds in the amount of $100 million by diverting the construction of road from the publication as required by the ordinance to his farm. A, as chairman of bid committee, received in the total amount of 30 million from 3 bidders who subsequently lost the bid, and misused 10 million funds for construction of building by not awarding the project to the lowest bidder. What is the crime committed? A committed the crime of malversation through culpa by lending his service vehicle worth 2 million to his driver, who did not return the same. A also malversed 10 million in his custody. A has a net worth of more than 50 million, which was way beyond his legitimate income. 2014 bar. What is the crime committed by A? A had committed series and combination of predicates of misusing government funds, receiving commission, and committing malversation. His net worth of more than 50 million is presumed to be ill-gotten wealth, since this amount was way beyond his legitimate income. Hence, the crime committed by A is plunder. Suppose the discovered net worth is less than 50 million. Will your answer still be the same? My answer is not the same. A is not liable for plunder. The amount of 100 million for construction of road misused by diverting it to his farm, the amount of 10 million misused by awarding it to the lowest bidder, and 2 million worth of vehicle taken by his driver through his negligence shall not be considered in determining if the 50 million threshold has been reached, since the road, the amount awarded to lowest bidder, and the vehicle taken by the driver are not his ill-gotten wealth. The amount of 30 or 30 million received from bidders and the 2 million misappropriated shall be considered in determining if the 50 million threshold has been reached. However, their total amount is not at least 50 million. His net worth is less than 50 million. Hence, the same is not enough to establish 50 million ill-gotten wealth as an element of plunder. However, A committed violation of Section 3, letter E of RA 1319 for causing damage to the government through evident bad faith and manifest partiality by diverting the construction of a 10 million worth road leading to his farm instead of the population in the exercise of his official function through evident bad faith and manifest partiality. Violation of Section 3 of RA 3019 for giving unwarranted preference, advantage, and benefit through evident bad faith and manifest partiality by awarding a 10 million worth of project for building construction to the lowest bidder. Indirect bribery for receiving the total amount of 30 million from 3 bidders who subsequently lost the bid. Malversation of service vehicle worth 2 million by allowing other person to take it through negligence, and malversation of unaccounted funds worth 10 million. Q. A gave B his pregnant and terminally ill wife sleeping pills to assist her in committing suicide. B took the pills to commit suicide, but she did not die. As a consequence, however, the fetus died. 1986, 2012, and 1946 bar exams. A and B are not liable for unintentional abortion or reckless imprudence resulting in unintentional abortion because taking abortive substance cannot be considered as violence, which is an important element of this crime. According to Justice Florence Regalado and CA Justice Luis Reyes, taking drugs is not physical violence required by Article 257 for unintentional abortion. A committed the crime of assistance to suicide. Article 253 of the Revised Penal Code imposes a penalty to one who assists another to commit suicide, although suicide fails to consummate, since assistance to suicide is a felony within the contemplation of Article 4 thereof. A is also liable for abortion, which is direct, natural, and logical consequence of the crime of assistance to suicide. Intent to abort, which is an element to abortion, is conclusively presumed. This is a complex crime of assistance of suicide with abortion, since these two crimes were produced by a single act of giving a poisonous substance. Because of Article 4, A is liable for the wrongful act done, and that is complex crime of assistance to suicide and abortion, although it differs from the wrongful act intended, and that is merely to commit assistance to suicide. B, in attempting to commit suicide, is not committing a felony. Hence, Article 4 is not applicable. Without the application of Article 4, she is not liable for the direct, natural, and logical consequence of an attempt to commit suicide. Killing the fetus should be treated as accidental. Q. A maltreated his pregnant wife. As a consequence, she was rushed to the hospital where she had a cesarean operation and fetus was delivered stillborn. The expert testimony shows that the fetus had developed to the stage of viability. What is the crime committed? The crime committed is abortion since the fetus is killed inside the maternal womb. 1979 bar. But if the victim fetus is killed inside the maternal womb, the crime is abortion or unintentional abortion regardless of its viability or its intrauterine life. In sum, regardless of whether the intrauterine life of the fetus is 6 months, 7 months, or 8 months, or 9 months, the accused is liable for abortion or unintentional abortion. 2015 bar. A fetus is viable if he can sustain a life independent from the mother. A fetus with an intrauterine life of 6 months is not viable. If the intrauterine life of the fetus is more than 6 months, he is considered as viable. Thus, a fetus with an intrauterine life of 6 months and 15 days is viable. 2015 bar. However, the viability of the fetus is not solely dependent on its intrauterine life. Regardless of the duration of its intrauterine life, an expert assessment of the doctor on the viable condition of the fetus must be given considerable weight. 1979. The 7 months rule under the Civil Code should not be confused with the 6 months rule under the revised Penal Code. Under Article 40 of the Civil Code, births determine personality. Under Article 41 of the Civil Code, if the intrauterine life of the fetus is 7 months or more, it is considered born if it is alive at the time of its complete delivery from the mother's womb. On the other hand, if the intrauterine life of the fetus is less than 7 months, it is considered born if it is still alive after 24 hours after its complete delivery from the mother's womb. According to Elmer Rabuya, the civilist, the cutting of the umbilical cord that connects the child from his or her mother completes such delivery. The 7 months rule under the Civil Code determines if the fetus is considered born for purposes of personality. On the other hand, the 6 months rule in the Detention case determines if the born alive victim is viable for purposes of abortion and infanticide. Embryo, fetus, and infant are persons since abortion and infanticide are crimes against person under the revised Penal Code. Q. Distinguish abortion from infanticide. The victim in abortion is an embryo, fetus, and born alive, a non-viable fetus. On the other hand, the victim in infanticide is born alive and viable infant with a life of less than 3 days. In People v. Paicana, it was stated that in the crime of infanticide, it is necessary that the child born alive is viable. There are 3 requisites to make killing of an infant constitutive of the crime of infanticide, to wit: 1. The victim did not die inside the maternal womb. An unborn fetus is not an infant, hence killing an unborn fetus, regardless of its viability or intrauterine life, is not infanticide but abortion. Number 2. The born alive infant must be viable. A born alive but non-viable fetus is not an infant for purposes of the crime of infanticide. Killing it is still abortion. And 3. The born alive viable infant must be less than 3 days old. Killing a child with a life of 3 days or more constitute the crime of parricide, murder, or homicide, depending upon the circumstance of the case. Killing of a 3-day-old baby is not infanticide, since his life is not less than 3 days old. The crime committed is murder, qualified by treachery. Minor children, who by reason of their tender years cannot be expected to put a defense. When an adult person illegally attacks a child, treachery exists. People versus Valerina, 2012 bar exam. Live-in partners killed their newly born child to conceal dishonor. If the victim is a non-viable fetus, the crime committed is abortion. If the victim is a viable infant with a life of less than 3 days, the crime committed is infanticide. If the victim is a baby with a life of 3 days or more, the crime committed is parricide. 2006 bar. A. Mauled his wife, who was pregnant for 6.5 months, without intent to kill her or abort the viable fetus. As a consequence, the wife died and the child was expelled prematurely. After 36 hours, the infant died. What is the crime committed? 2015 bar. Killing of his wife is parricide. The killing of his infant is not an intentional abortion because the victim was born alive and viable for his intrauterine life, being more than 6 months. Killing of a born alive and viable infant with a life of less than 3 days, 36 hours, is infanticide. Since the single act produced parricide and infanticide, this is a complex crime. Now, if the child died after 3 days, the crime committed is parricide, and that constitutes a complex crime of double parricide. Who are liable for parricide? Parricide is committed by any person who shall kill his father, mother, or child, whether legitimate or illegitimate, or his legitimate other ascendants or descendants, or his legitimate spouse, without the qualifying circumstance of infanticide. 1947, 1948, 1957, 1960, and 1999 bar exam. An offender who killed his illegitimate mother, 2012 bar, or illegitimate son or daughter, 1982 and 1999, is liable for parricide, but one who killed his illegitimate grandchild, illegitimate daughter of his legitimate son, is not liable for parricide. 2012 bar exam. The crime committed is murder or homicide, depending upon the circumstance of the case, with ordinary aggravating circumstance of relationship. As a qualifying circumstance under Article 246 on parricide, relationship between grandparent and grandchild must be legitimate. As an alternative circumstance under Article 15, relationship between grandparent and grandchild may be legitimate or illegitimate. An offender who killed his illegitimate grandchild, who was asleep, and taking his wallet afterward, is liable for murder, qualified by treachery, and aggravated by relationship, and theft. The crime is not parricide since the relationship of the offender in this crime with his ascendant other than his child must be legitimate. 2012 bar. Robbery with homicide is not committed since the original design of the offender is to kill the victim and not to commit robbery. 1970 bar. Killing legitimate brother is not parricide since he is just a collateral relative of the accused. 2012. An offender who killed his illegitimate spouse, 1948 and 1999, or common law wife, 2012, is not liable for parricide. In parricide involving spouses, the best proof of the legitimate relationship between the offender and the victim is their marriage certificate. However, in proving the legitimate spouse relationship between the accused in parricide and the victim, the court may consider oral evidence if the same is not contested. 1978. One who killed an adopted son is liable for homicide and not parricide, since the relationship by adoption is not within the contemplation of Article 246 of the Revised Penal Code. However, ordinary circumstance of relationship shall be appreciated. Article 15 of the Code covers relationship by adoption. Under Section 17 of RA 8552, the adoptee shall be considered the legitimate son of the adopters for all intents and purposes. 1999. But a mother killed the 3-day-old child of her husband with their daughter. Killing the victim is not infanticide, since he is not less than 3 days of age. Killing the victim as her illegitimate grandchild by consanguinity is not parricide, since illegitimate relationship between grandparent and grandchild is not a qualifying circumstance. Killing the victim as her stepdaughter or daughter by affinity is not parricide, since blood relationship except spousal relationship is not a qualifying circumstance. However, killing of a 3-day-old baby constitutes murder qualified by treachery. 2012 bar. Q. Isagani lost his gold necklace bearing his initials. He saw Roy wearing the said necklace. Isagani asked Roy to return to him the necklace as it belongs to him, but Roy refused. Isagani then drew his gun and told Roy, "If you will not give back the necklace to me, I will kill you." Out of fear for his life and against his will, Roy gave the necklace to Isagani. What is the crime committed? What is Isagani liable for? Isagani is not liable for robbery because he is the owner of the property taken by force. However, he is liable for grave coercion. Taking the law into one's hand is not lawful. 1998 and 2018 bar.